morning, everyone, and welcome to the 15th in our series of breakfast briefings with me, Kaz Carrington. Just to let you know, on technical support today, we have Mariana Honorato from GoHo. So if you have any technical problems, issues, then please say something in the chat and Mariana will get onto it. With regard to questions for the content today, we can't answer those in chat, but if you'd like to email me, then that's absolutely fine and we'll get back to you, obviously, about the content of today. Just to remind you before we start that we will be running the Law on Tour in November. This is a brilliant one-day employment law update event that we run twice a year. It's CPD certified, so you'll get continuous professional development points because you get a certificate afterwards. We have great content every 6 months, completely new event. So we cover everything that's new in employment law, and there is lots coming to us, isn't there? Lots of acts that we're waiting for implementing regulations for, and we cover all new important case law, and we also cover those really difficult, tricky matters that HR folk have to deal with on a sort of daily, weekly, monthly basis. And we'll also be looking at artificial intelligence. How's that going to affect our jobs? In many respects, it might make things a lot easier in some areas, but maybe a bit scary in others. So we're going to be looking at that. So if you're a charity, you get 15% off. We have great venues, you get a great lunch, and we have a bit of a giggle as well. So it's not all hardcore employment law. So if you're interested, please call us on the number at the bottom of this slide or email us at klc@klcemploymentlaw.com. and we'll tell you more about it. Okay, so what are we going to talk about today in this 30 minutes? Well, as ever with the briefings for 30 minutes, we really just scratch the surface, and it's a case of an overview, an introduction, a kind of watch out for, and I guess really highlighting some of the points that you might want to look into further. And again, for some, it might be just like let's just remind ourselves of the basics, because very often, especially if you have been in HR, ER for a few years and you're experienced, you tend to sort of forget what the law says, because that's what we always do in our organisation, and that can be quite dangerous sometimes. And very often the courts will throw us back to the law and say, look, I know what the Code of Practice says, I know what guidance says, but this is what the law says. So really this is what we're looking at today. So first off, we're going to look at diagnosing the behaviour. What do we expect to see in poor performance? Because it's distinct from other types of behaviour. So then we have to choose the correct procedure and the correct approach, because again, we're looking at not only having the potentially, and we have to always be a little pessimistic, it could result in a dismissal. So the potentially fair reason for dismissal, but also we need that fair process, because without the two together, we know that we're not going to achieve a fair dismissal. So then a quick look at underperformance and ill health. And really what I'm talking about here is when somebody may have a disability, because if it's an ongoing ill health issue, if it's a chronic ill health issue, it's very, very likely to be considered a disability under the Equality Act. So what do we do then? And what happens when people really underperform, then they get better, but then they kind of have a regression? So we'll look at that. So first off, now this is a slide I have used for many, many, many years, and I just think it's really helpful. And people often say to me, Cass, I really love that slide because it really makes me understand what you're talking about when you're mentioning the different approaches, the different tone to use, and it helps me really concentrate down into where I should be in terms of procedure. So just very briefly, you can see on the right hand side, we've got people who are persistently absent. There's no underlying medical cause. It's just people who are just unlucky to be presenting with lots of different ailments. And if we deal with them, it's on the basis of, we would like you to improve your attendance. Not we'd like you to get better, because we can't actually will that on anybody, but we'd like to improve your attendance. So we're giving you warning. If you don't improve, it will be a dismissal. Now, that's always going to be for some other substantial reason. Then we've got our conduct issues in the middle. This is where somebody is willfully disobeying our rules. They're willfully disobeying our ethos, our culture. They're going against it. And in that sort of situation, we deal with it with what I call short, sharp shocks. Don't do it again. Once we actually have investigated and found you've done this, don't do it again. If you do it again, or you do anything similar, which is misconduct, you're going to find yourself back in this forum, actually, and there'll be another warning. And that is, if you like, blameworthy. So we've got our sort of persistent absence. We're not really blaming you. It's not your fault. You're unlucky. Then we've got the middle, blameworthy. It's you've done something wrong. We are blaming you for it and saying, don't do it again. Please get better and behave more in line with our culture. And then on the left-hand side, you can see we've got the can't do's, the capability issues. Now, left-hand side is ill health. Of course, the person can't help being ill. We never would blame anybody for being ill. And we have a very different approach, that we have a very sympathetic approach to those people. But there we also have, you can see there, skill or aptitude. This is where we get our poor performance issues. And again, it's a can't do. Somebody can't do the job. Despite our training, despite our coaching and mentoring, they still can't perform to the standards that we require. So this requires a different approach. It's still very much procedural. It still very much is hand in hand with formal warnings if they don't improve after our informal approach. And it still might result in a dismissal, but it will be by capability, okay? So we're looking here at what we would call non-blameworthy actions, so non-blameworthy. And that's really important, I think, when we're considering how all our actions and all our meetings and all our conversations would play back if we got to an employment tribunal. We want to be able to actually show that we've taken the right approach and we've taken a fair approach. So just filtering down here, diagnosing the problem, it's a capability issue. Here we've got the 5 potentially fair reasons for dismissal under the Employment Rights Act, Section 98, capability, conduct, redundancy, statutory bar, some other substantial reason. So remember, we're going for capability, and we also need the correct procedure as well. So really important. Now, often it's difficult in the first sort of instance to know whether somebody is willfully doing something or whether they just can't do it because they haven't got the skill, aptitude, training, etc. So very often we do give people the benefit of the doubt, unless it's absolutely blooming obvious that they know how to do it, but they're just being lazy. So very often we take the approach of, let's give a bit of coaching, counselling, and see if we can get the person on track. Okay, so that's where we are with this. Now, just back to diagnosing this problem, just if you wanted to go and look at the piece of law, and I often say to people, as I say, go back, look at the law, see what it says. It really is helpful. Section 98(2)(a) of the Employment Rights Act talks about this, and it says, relates to the capability or qualifications of the employee for performing work of the kind which he, that's the wording, was employed by the employer to do. And then at section 98(3)(a) of ERA, it says capability in relation to an employee means his capability, again, not my wording, ERA's wording, assessed by reference to skill, aptitude, health, or any other physical or mental quality. So if you want to go back and see, where does this all come from? I don't understand. I know what the Ethics Code of Practice says, but where does the law say it? It's there. Okay, so that's always good to refer to. Now, okay, we've diagnosed essentially that this is a can't do. We've given the person, if you like, the benefit of the doubt. It isn't their fault, essentially. And if somebody has now started performing badly after, let's say, and this happens fairly regularly, they've been confirmed in post, they might have been with us for months, even years, but now they're not performing well, then obviously we have to look and see, well, what is contributing to that failure in performance? Perhaps it's that we've introduced something different in the way that we do our work. Is there any new system? Is there any new contacts? Who's the manager now? Are there any new matters that might be influencing the quality of the person's performance? In other words, we're kind of looking for reasons why their lack of performance is an extraneous reason. Okay. And the reason that we want to do that is because if we have employed somebody, and I know when you're going through the recruitment process, we have all sorts of different ways of doing it. Psychometric tests, it might be, I know, interviews, it might be, they have to do a presentation, it might be myriad ways of actually recruiting and selecting somebody. At the end of the day, even a reference really only tells you what somebody else thinks of somebody. It comes down to what we think. Now, we have employed them and then they've gone through the probationary period. So to all intents and purposes, the way that the tribunal view this is, you recruited this person, you had the opportunity to do something about it, clearly early doors, you haven't. So what's the reason? So you, employer, have really got to show me that you really believe and you can evidence this is poor performance and this isn't other reason that you've just maybe kind of, trumped up maybe to dismiss this person at this point. And also, by the way, if you have made a silly error in recruiting the wrong person, that is your fault. So you need to show us, that's the employment tribunal, that you've done everything you possibly can to keep that person employed, to get them up to standard, because basically it's your fault. So think of it of us always being on the back foot when it comes to this particular area. Okay. Now, with regard to the tone, etc., in the meetings, we need to be clear that we are helping somebody. Okay, we need to be clear that we are doing what we can to train them, to bring them up to scratch. So when I say tone, which I did in the previous slide, I really mean think about the language that you're using. And remember, it's not blameworthy behavior. This is non-blameworthy. So all of our interactions with the individual need to be on that basis. Now, that doesn't mean to say that we don't say to the individual, look, we have been going through this process and informally we've been, giving you some extra tuition and guidance, but actually that hasn't worked. And now we really need to move into the formal procedure now. Now, at that point, that person really should be made aware that we're hoping that we can turn things around and, we're going to give you time to improve, but be aware that at the end of this process, if you haven't improved, that might result in your dismissal. So we're going through guiding people, making sure that they feel supported, but we mustn't let them run away with the idea that this is just happy clappy and nothing bad is ever going to happen and they can just carry on, because that is unfair. So remember, we've got to give them futurity. They've got to have an understanding of what could happen to them. So that's what we're talking about. We've got to advise of the consequences of failure. Now, what does the ACAS Code of Practice say actually about monitoring support? Well, it says, we should support people. And actually, it talks about, in the first instance, a quiet word, and that's to do with conduct or capability, actually, or poor performance. Be wary of codes of practice. And I don't mean to say disregard them, because when it comes to the ACAS Code of Practice on disciplinary and grievance procedures, you really don't want to disregard it. But there has been times, and this even applies to that particular code, when the code oversteps its brief and essentially misinterprets the law and perhaps doesn't even keep up to date with case law. And I'll just give you an example. In the introduction to the code, it talks about employers, probably have a separate capability procedure. And by the way, if you are anything but a small employer, you'll be expected to have a separate procedure. But it goes on to say you may prefer to address these poor performance matters under that procedure, which is quite strange wording, because we know that if you were to use the tone, use the types of warnings for somebody who is underperforming, if you use the tones of warnings that you would use for a misconduct matter, don't do it again, and not giving anybody any support or time to improve, then that would be unfair. So This is why I always want to throw you back to the statute. What does it actually say? What do we actually need to do? And obviously always having in mind to case law. Because remember, case law interprets the law. It tells us how that law works. It tells us how the courts have got to understand that piece of law. So as I say, don't just ever disregard a code of practice. And by the way, the ACAS code of practice, it's a statutory code. And so it will be used in tribunal. The tribunal will look at it and say, let's see if you followed the code. And hopefully your own policies and procedures will be in line with that. Okay, so we're in our formal procedure now. Who's going to undertake the hearing? Well, if it were a disciplinary misconduct matter, we'd be saying we want an investigator, somebody separate, we want a hearing manager, somebody separate to hear the appeal. Now, with poor performance, it kind of is slightly different because oftentimes you won't need to have a formal investigation because you've already got that information because the manager would have been monitoring the person's performance. And sometimes it might be the line manager that hears the matter. We would all suggest if you can, it's always best to have another manager coming in to hear the matter and obviously clearly another manager hearing the appeal. So if you're an organisation that can do that and you've got that structure, then please do. The warnings will take the form of formal warnings, so formal first written, final written, and obviously the end would be dismissal, but with time to improve and with checks in between, monitoring constantly throughout that period, and then a review. Now, people often say to me, well, how long do we have to give people to improve, Cass? We say in our organisation, 12 weeks. Well, actually, it depends on the job. If it's a very, very simple job where somebody can demonstrate competence within an hour, within a minute, then clearly not long. If it's a more technical job, or if it's a job where the individual is being judged on monthly, quarterly results, then clearly you have to align to that, because how can you possibly get the person to demonstrate competence if you don't go along with where they have to achieve their targets? So that will depend on that. But remember, we're talking to the person in between, we're monitoring, we're seeing how they're going. And then obviously we're aware that the person might then have to face another hearing. Now, if they have achieved the required standard, brilliant, that's fantastic. But remember, their warning for that poor performance will still be lasting for however long you have said. So if probably 6 months in the first instance, could be a year. Okay, so that's to help us if they regress. Okay, appeals, obviously, we always give people the opportunity to appeal any disciplinary formal warning, whether it be poor performance or misconduct. And again, we would do that for this process as well. Okay, let's get to the point then where we haven't seen an improvement in competence. We might have seen a small improvement, but it isn't to the standard that we require. And remember, we need to see those standards are our standards, achieved. We're nipping things in the bud. We're getting things sorted quickly, or not letting the grass grow underneath our feet. And something to say here, I guess, is if you have allowed somebody to underperform for a length of time, sometimes I hear a very length of time, and it usually comes to light when a new manager comes into the organization, they start managing somebody and say, really, hasn't anybody ever told Vanessa that actually she has to do some work, not just kind of drink cups of coffee all day? And has everybody told Fred that he shouldn't just be going out for cigarette breaks all the time? So when that happens, again, the courts are onto us if we don't give that person the benefit of more time to adjust. And effectively, what you'd be saying is we've allowed that person to languish in the false hope that they can carry on with this for the rest of time. Now we're saying things are changing. We're putting our marker in the sand, but we do give more time for that person to improve. So again, you're just flagging up that you are aware that this has gone on for too long. Now things have to change. It could be actually that we allowed you to do that, didn't mind having 20 coffee breaks. Actually, now we need to be a bit more competitive. So this is why we're changing. Again, the same approach. We're demonstrating that we're cognizant of the fact that sometimes it takes people a while to kind of like get with the program. Okay, now if we got to the point of dismissal, then before we consider that, or before we would take the decision, should I say, to dismiss, it is a prerequisite of fairness that we consider, is there anything else we can do with this person short of dismissal? Is there any way we could maybe effectively demote them? Could we redeploy them? And when I say this, people say, oh, managers don't like that because they just think they're being dumped on you, or been giving somebody who's up, substandard. That is not the case. Very often people underperform because we have promoted them to the level of their own incompetence. So they were great as a supervisor, but they're not just making it as a manager. Even with all the management training that we've given them, they're just not cutting the mustard. And so sometimes relieving them of those duties is a blessing for them and can help us as well. So it's something we consider. However, the person would have to agree to that unless we have demotion as a sanction. So the person would have to really agree to that because it is a change of their contract. And often people are like, no, it's too humiliating. I don't want to accept. I don't want to go back to where I was. But we must evidence that we've considered that. And even if we can't do it, we must be able to evidence that we did look around, we did think about it, we did consider that possibility, because otherwise we will not have acted fairly. And remember, potentially fair reason and a fair process as well is absolutely required. Let's move on to talk about the issues if the person is poorly and, as I said, very likely to be considered disabled under the Equality Act. So once they are at a substantial disadvantage because of what we require them to do under their disability, then we have the duty to make reasonable adjustments, as you know. And those adjustments will depend upon what's reasonable according to the sort of organisation you work in. If you work in a massive, wealthy organisation, then you will be expected to do quite a lot. If you're in a small organisation where money is tight and resources are tight, then obviously you're a bit expected to not push the boat out quite so much. First of all, it's really important to see if there is a link between their ill health and their poor performance. Now, sometimes there isn't. There was quite a recent case with somebody who had a chronic disability, I think it was multiple sclerosis, and after her probation, they didn't confirm her because she wasn't actually performing to the standard they wanted. She was meant to build business development manager. She wasn't doing that. They didn't confirm her, so they dismissed her, and she then brought a claim saying this is disability discrimination. Well, actually, it wasn't, because she could not make the link between her disability and obviously the underperformance. So the individual has to make that link. There has to be that causal link. So if we can say, well, actually, there absolutely is no link, and sometimes it's we can do that with the help of occupational health, but oftentimes the disability is contributing to the poor performance, and obviously that's when we would make those adjustments, and hopefully that would mean the individual was able to perform. Now, at its most basic form, that would be, I'm in a factory and I have to produce 100 widgets a day, but I can't because I've got a slight impairment of my arm, which is a disability. So my target is down to, 70 widgets a day. That's the adjustment you've made. I can then perform to that standard. Everybody's happy. It could be, however, that we can't reduce the standard. You're going to be client facing. You can't suddenly say, oh, well, you can give the client a substandard training session or piece of advice. It doesn't work like that. But what we put in place are resources to help the individual meet that standard. But if, even with the best will in the world, with all those adjustments, the person is still underperforming, then I think we have to take a view and say, well, actually, this is no longer, in my view, considered to be a poor performance matter. This really is a capability ill health. And I always think it's kinder to then move that person effectively into that arena where we're saying, we can't make any more adjustments. The adjustments that we're making aren't making you able to do the job, and therefore we're looking at an ill health capability dismissal. Okay, so obviously that's a lot. I've skimmed over that, and that's a very in-depth area, as you will know, but kind of that's the basics of that. So we try to bring that person up to standard. Okay, what about then if we get the person to competence, they demonstrate competence, however, they then go back, they regress. Now, if somebody is already on their warning, let's just say we've given them a warning that's going to last for a year, and we've said to them, well done, you've kind of achieved this, but that warning is still live. So if they've regressed, we might decide that, okay, it is the capability, they've obviously for whatever reason sort of fallen backwards. We'll go through the capability machinations again, but next time they might be on a final written warning. Now, what tends to happen in my experience is that somebody will be on a warning, let's say only 6 months, a year, that then elapses, the life of the warning is spent, and then they regress. And that means that some employers think, I've got to start all over again, right at the very beginning. And it feels as if almost the employer is being played a bit. So, you know, okay, so you've waited till that warning has elapsed, and now you're going back to sort of your old ways. Now, what could have happened is that there might have been something introduced, again, which has affected the person's ability to perform well. So again, we're back to, have we introduced any new standards? Have we introduced any new systems? Have we introduced any new personnel? Is there something that's actually contributed to the person's inability to perform? In which case, we'd just go back to capability, because that's fair. However, if none of those things are present, if it's just that the person has out of warning now, so I'm just going to ease off, it could be that we might take a different diagnostic approach, and that is you actually evidence competence. Now we know you can, and you have regressed. It must mean that you won't. So we've gone from a can't do to a won't do. Now that means that we can hop on to, rather than looking at poor performance with the time that takes, because it does take in some situations a long time, we can go from that to a conduct and misconduct procedure, whereby we're saying, you have got the competence to do that, you just didn't do it. You've given us an excuse, you've told us why you didn't do it. I'm sorry, that we're not buying that. We don't believe it. What we believe is that you have decided that something else is more important, you know, like your coffee break or your cigarette break or actually surfing the internet. So we can take it from, now we know you can, it must be that you won't. Okay, but those things have to be in place. As I have mentioned, we have to go back and say, what has kind of like possibly made this person have a regression? Is there anything? If there is, we're in capability. If there's nothing, then actually, are we now saying, having given the person the benefit of the doubt, we now believe that that is a won't do, which is a conduct matter. Okay, right then. Just to say, that's all I want to say with regard to poor performance. I'm sure you've got lots of questions or just things that you're thinking, I'm just going to go and have a look at that. Remember, you can email me on that email address shown on this slide. And again, I'm going to remind you, if you want to know more, if you want to understand what's coming down the line, if you kind of like the style, if you like it a little bit lighter, your employment law served as a lighter dish, as I try to dish up, then come to the Law on Tour. It is a brilliant event. As I say, you will not regret it if you haven't been before. And you also go away with brilliant documentation, and that will serve you well for the next 6 months until the next Law on Tour. In any case, I shall say my time is up. Thank you so much for joining me this morning. I hope you have a lovely day. And when the weekend comes, I hope you have a brilliant weekend. But for now, thank you very much and goodbye.